Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. As you know, in this series we interview and speak with many of our members from all over the world. The expert we have today with us is Oksana Zadniprovska from the law firm Axon Partners, that is a full-service law firm from Ukraine. Oksana is a partner and she is also one of their experts in privacy, data protection, and technology-related law. And I'm very pleased to have her with us. So first of all, thanks a lot, Oksana, for being with us today.
Thank you for inviting me here.
And yes, Oksana, as you know, the Privacy Espresso series is a very short and quick interview. So I would like to immediately move with our first question. We are very interested to know a bit more about Ukraine in relation in particular to exchange of data, so data transfer. My first question to you would be, what's the stage in relation to Ukraine? So is it safe in your view to exchange data with Ukraine? What is the situation there, in particular, considering that Ukraine is not yet an adequate country under the EU perspective? So what should we be aware of as a starting point?
Okay, as a starting point, there will be a spoiler from me that, of course, a lot has changed in Ukraine due to the war when the war started. But, okay, it's not that safe as it was earlier to transfer data to Ukraine, but still there is some light at the end. I'll show where a little bit later. But in general, I would say that we need to start from where the transfer where there is transfer. So the DPB has explained that the transfer is when any kind of access is provided. So it's not only about transferring actual base of database to some country. It's even when the data exporter in any way makes the controlled data available to the data importer in Ukraine. And this is what we should keep in mind. That this is international transfer, and for the purposes of the GDPR, you are right that Ukraine is not in the list of the countries which provides adequate level of protection to personal data as of now. But in general, this means that the quick and practical choice for us would be to apply the Standard Contractual Clauses, the SCCs. But before signing the SCCs, of course, it is important to decide if the transfer is safe and if the data exporter shall perform the data transfer, the impact assessment. Of course, this transfer impact assessment should be done for Ukraine too.
Yeah, and I think that you already touched, my next point, that is, the classical step for anyone that wants to exchange data, as you were rightly saying. I think it was important to underline what does exchanging data mean, because it's not just, the classical situation when you send data to someone, but there are many situations that are in the middle, let's say, in which you need indeed to conduct a transfer impact assessment. So for what concerns Ukraine, what should be done? What should EU companies in particular exchanging data with Ukrainian ones or in Ukraine keep an eye on?
So first of all, when we, for example, get the request to help with the transfer impact assessment, we firstly ask the client like the details on the particular transfer. It is really important to understand which data is transferred, for what purposes, like for storage, for the analysis, or for support of any kind, or for including into the databases. After that, we describe the up-to-date laws and practices on personal data protection, on surveillance and disclosure of personal data on request of the authorities, as well as the efficiency of the judicial system and enforcement of data subject rights in general. Then we advise to, we help to decide if the protection is enough. This is the hardest part, because usually you have to, of course, we want to say yes every time that the transfer is safe and it's okay to transfer data to Ukraine. But of course, in most cases, there should be some additional safeguards applied in order to minimize the risks which could be present. And of course, every time we remind the data importer that they have certain obligations, so they have to monitor these laws and practices, because every day something could change in the laws or in the court practice. So we need to keep our eye on it.
Yeah, and staying up to date is essential, in particular in a situation like the one in Ukraine, where probably everything can change from one day to the other to another. So that's definitely important. And as you were rightly saying, whenever we speak about data transfer, one of the key issue, and this is also in the experience between EU and US, to give you an example, not to you but to our followers, of course, is the one related to access to personal data by law enforcement agencies. How can we protect them if we can, and how it works. So I think that my next question would be to this very focal point that is even more, let's say, sensitive in your case. So, how does it work, the discipline related to law enforcement in accordance with your law, and in particular the martial law in Ukraine?
Here comes the main question, right? We can divide it into two questions. The first question is, are the human rights respected in Ukraine during martial law? And the second question is, are the restrictions that we have limited to what is necessary, proportionate in democratic society? So starting from the first question, the human rights, yes, they are respected because we have, we are the party to the European Convention of Human Rights and the Convention 108. We have the principle of the rule of law, which is included in our constitution, together with the protection of the right to privacy. Ukraine has also a separate data protection law starting from 2010, which is updated from time to time. And we have this data protection authority, which may audit companies for compliance and which may handle data subject complaints and impose fines. Also, Ukraine has this GDPR-like draft laws in the parliament, which are not yet adopted, but which are in the process. And finally, we have this EU candidate status from 2022, which is gives us the hope that we will get closer to the EU in relation to the standards and principles. So now let's come to the more complex issue, which is the restrictions and the law enforcement and their access to personal data. So earlier we could rely on this data protection law, which says that the privacy rights could be restricted only to the extent which is necessary in democratic society. There is a particular article in our law which says that it could be done only in the interest of the national security, economic well-being, or protection of the rights and freedoms of people. So earlier, no law allowed silent or indiscriminate surveillance activities. Also, our criminal procedural code introduced this independent oversight mechanism. What I mean is that access to personal data could be only on the basis of the decision of the investigator or judge, and there were options on how to contest the procedural violations before the judge and so on. The problematic issue, what we had earlier and what we still have now, is limiting the scope of data which could be accessed by the authorities within these criminal procedures. But in general, like the SCC, before the war, let's say two years ago, the SCCs were enforceable. There were no questions about this. Although now everyone knows that Ukraine is at war, and we have this martial law, which allows the restriction of the constitutional rights of persons in cases prescribed by law, which includes privacy rights, unfortunately. And the criminal procedural code, for example, allows the prosecutor to temporarily access metadata on communications, medical, bank, and other personal data without the court decision. If there is, but the important condition is that only if there is no objective possibility for the investigating judge to exercise their powers. So the idea is that they wanted to allow quick investigation, even when the judge is, for example, killed by the missiles while the prosecutor is safe. But it also opens doors to abuse of powers, unfortunately, and in general makes the independent oversight mechanism less effective. However, in most cases, we could say that the safeguards which existed before the war are still applicable. We still do not have this law which allows silent or indiscriminative surveillance activities. In case of abuse of powers, a person still can, during the search, for example, or the seizure activities, the company or the person should still apply the same mechanisms to contest the decisions and to go to court, to try to disregard this unlawfully collected evidence or initiate criminal investigation for the abuse of powers. by the prosecutor, and then ask to compensate for damages in the civil proceedings. And the information received during the investigations, this information shall not be disclosed and shall be protected, as it was required earlier. It is still required now. So a person may exercise the rectification right by the court or by ombudsman, and also the data importer still can effectively inform the data exporter when, for example, they are under the surveillance or the criminal investigations. So in general, Ukraine never ensured the essentially equivalent level of personal data protection to those that is in the EU before the war or now, but the SCC could still be enforceable even in war times. Of course, it's like each case should be analyzed on a case-by-case basis, but in general, I would say that it would be all about the safeguards and the data minimization.
Perfect, Oksana. Thanks a lot for this very interesting introduction to your actual, situation and framework. It doesn't sound that complex, but probably because if you have an expert that flanks you in these activities, it is doable and it is possible. So we would like to warmly invite everyone having business and exchanges with Ukrainian companies to, give you a call or send you an email just to make sure that they can be supporting you do things properly. Because of course, under the EU perspective, there are checks even for companies working with Ukraine. So you need to be compliant, and there are possibility to do so. So, more or less the type of mechanisms from what I'm hearing are similar to what you have to do for other countries. You not just need the, right assistance with people that knows how things are moving forward in the specific countries, and that's why we normally rely on local experts that are update on a daily basis on what's happening there. So even more in your case, I think it would be relevant to be in touch with an expert. I would like to thank you very much for your time and your quick but very effective explanation today. I would like to thank you also all our listeners for being with us today, and I look forward to meeting you all to our next Privacy Espresso. So thank you very much, Oksana, again, and thank you all. Bye, everyone.
Bye.